Call the meeting of the Marshall County Fiscal Court, special meeting for the final reading of our ABC Ordinance 2015-04. Welcome everyone to the meeting. We're glad to see you here with us this morning. Again, this is a meeting where simply the commissioners and I will be listening to our summary reading from our Assistant County Attorney, Jacob Darnell, and there will be discussion perhaps, and I will call for a vote to pass. This shouldn't last very long. Appreciate your attendance this morning. Jason?
All right, thank you, Judge. As she said, the good news is I'm not going to do a full reading today, so this will just be a summary. I'm going to go through this section by section. There have only been two very minor changes since the last time we met here, and I'll let you know what those are when we get to it. But without further ado, I'll go ahead and get started here. This is ordinance number 2015-04, an ordinance regulating the sale and consumption of alcoholic beverages in Marshall County, Kentucky. Section 1010 is just the title. Section 1011 is the purpose, which is to establish uniform regulations over the sale and regulation of alcoholic beverages in Marshall County. 1012 adopts state definitions. 1013 talks about the scope of this ordinance. 1014 adopts state law. 1015 talks about license generally. 1016 talks about license fees. Am I good? The quota retail package license per year, $1,000. Special temporary license per event, $166.66. Why that is, I don't know. Non-quota type 2 retail drink license includes distilled spirits, wine, and malt beverages per annum, $1,000. Non-quota type 3 retail drink license includes distilled spirits, wine, and malt beverages per annum, $300. Special Sunday retail drink license per annum, $300. Non-quota retail malt beverage package license per annum, $400. Non-quota type 4 retail malt beverage drink license per annum, $400. Limited golf course license includes distilled spirits, wine, and malt beverages per annum, $1,400. The holder of a non-quota retail malt beverage package may obtain a non-quota type 4 malt beverage drink license for a fee of $50. The holder of a non-quota type 4 malt beverage drink license may obtain a non-quota retail malt beverage package license for a fee of $50. Any amount paid to any city within the county as a license fee for the same privilege for the same year may be credited against the county fee. 1017 talks about special licenses and defines what types of licenses are allowed. Not allowed, but what we can issue. 1018 talks about expiration of license, proration of fees. 1019 is dealing with payment of license fees and delinquency of those payments. 1020 talks about refund of fees, if applicable. 1021 is the regulatory license fee, and that is 6% of gross sales of all alcoholic beverages by the drink. Retail sales of packaged distilled spirits and wine, the regulatory license fee shall be 6% of gross sales. Regulatory license fee shall be 6% on gross retail sales of packaged malt beverages. So 6% across the board on everything on the regulatory license fee. Those are going to be paid quarterly by forms that Wendy's working on. We're close to having those done. And that's pretty much it on that. 1022 talks about the disposition of fees. And of course, those are earmarked for, the regulatory license fees are earmarked. Section 1023 establishes the Office of the County Alcoholic Beverage Control Administrator, talks about requirements of that job, duties, responsibilities, who can be ABC administrator, who would not be eligible to be ABC administrator, the oath to be taken. Section 1024 talks about advertisement for those people who are interested or entities who are interested in advertising or applying for a license, the advertising requirement. And while we're on this, I would just want to say to all the people who are interested in possibly applying for a license, please don't rush out right now and put anything in the paper yet, you're going to have to wait until we have our forms ready. Wendy's been working on those very, very diligently, and she's done an outstanding job on those. And she says she might be able to have them done by today, Monday at the latest. So I would think that either this afternoon or maybe Tuesday of next week, that she and I can get together and make sure that they all line up to what our ordinance and state law requires. And at that point, we're going to be ready for you guys to come pick them up and start filling them out. We're not officially wet until October the 4th by statute, so that's a Sunday. So Monday, October the 5th would be the first day that we could accept an application.
And it's not necessary to also, Jason, to advertise. According to Steve Humphreys, if you advertise what you're required to by law and you do it for that 60-day period, it's neglected, so
Right.
wasting your time and money.
I think Wendy's going to give us a timetable after we get through that tells everyone when they can do what they can do.
And one other thing on advertising is that there's some specific language that you have to have in your advertisement by statute, and we've actually quoted that in our ordinance. So we need to make sure that you have that in your advertisement when you're doing that for the paper. Okay, moving on here. 1026 talks about the form of the application. Again, Wendy's been working on that. We're close to having those completed. 1027 just talks about some conditions on the applications. 1028 deals with what the actual licenses themselves the information that will have to be contained in those. 1029 is a requirement that any person with a license keep the county updated on any new information or change in ownership. 1030 talks about renewal of licenses. 1031 deals with lost or destroyed license, $10 fee for a new license. 1032 talks about revocation or suspension of licenses and the grounds that can be the basis for that. 1033 talks about the procedural aspects of a revocation or suspension, a hearing, the right to appeal. 1034 deals with transferring or assigning a license, what's required for that. There's a $100 fee attached to that to transfer a license, and then what a transfer of ownership entails if it's an entity other than an individual. 1035 talks about refusal of licenses and the guidelines for approval of quota licenses. 1036 deals with review of licenses, books, records, and reports. 1037 is dormancy. 1038 is hours of sale and delivery. There's been no changes on that since the last time we met and talked about that. 1039 just deals with several mostly statutory conditions, prohibitions, and restrictions. 1040 deals with possession of minors possession by minors prohibited. No person shall aid possession by minors. That's all statutory. 1041 deals with consumption on licensed package premises prohibited, congregating on certain ABC licensed premises and vacant premises prohibited. There's some definitions in there. 1042 is the malt beverage keg registration. No changes there. 1043 authorizes all certified peace officers and the county ABC administrator to enforce this ordinance. 1044, the mandatory responsible beverage service training. This is one of the changes that I made since the last time we were here, and I talked with Greg Northcutt, who's the city attorney for Calvert, who talked with Steve Humphreys, and he suggested that really the only change that we need in that was all persons employed in the selling and serving of alcoholic beverages by the drink shall be required to do the mandatory service training. Humphreys was of the opinion, and I think Murray got shot down a couple weeks ago when I was talking to Warren Hopkins, who's the city attorney for Murray, that they didn't have that limiting language by the drink in there. It just applied to everybody. Humphrey said he thought that if you did buy the drink only, that it would fly, so that's the reason we changed that. 1045 deals with signs and advertising. This is a change here. There is a specific regulation dealing with certain types of signs that are allowed, malt beverage in particular. So I've added a phrase there at the beginning, unless expressly permitted by state statute or regulation, and then the rest of those requirements are the same. 1046 is patio and outdoor sales. Been no changes there. 1047, it just deals with conflict, severability, record of proceedings, and appeal. 1048 deals with the penalties, no changes there. And then there was one other change that I made. Which one was that? No, what was the one we did, that we talked about yesterday? Oh, about the inspections.
Oh, yeah, we changed the language on that. But I think we just changed that on the application, didn't we?
No, it's in the ordinance too. Here it is, 1027. The county ABC administrator shall not grant any alcoholic beverage license or approve a renewal of a license unless the applicant in his place of business shall have been approved by the Marshall County Building Inspector and any and all other inspections as may be required by the Kentucky Building Code or State Fire Code. And what I added was this phrase at the end, as may reasonably be accomplished under the circumstances. And the reason for that added phrase is just to give the building inspector a little bit of discretion, because not all buildings are created equal. Some of them are going to be, some businesses are going to be older buildings, some may be new buildings. So when the building inspector goes in, it's not going to be the same for every building. So there's just some added discretion in there to allow him to make a call on that. So, and that is the summary of ordinance number 2015-04.
Gentlemen, do you have any questions of Jason about the ordinance?
About the state statute on the signage?
There, basically, it's a regulation. It's not a statute. It says that a malt beverage distributor can allow a malt beverage retailer to display signs. So the way that I read it, you're talking about, Budweiser, Miller Lite signs on the outside of their premises. So that's what the regulation says that they can do, and of course, we can't override that. That ties our hands. So.
Is there anything else? I think then at this time, I would entertain a motion that we approve ordinance 2015-04 on our ABC ordinance. I would entertain a motion on that.
Move that we adopt, Judge.
Is there a second? Second. There is a motion and a second. Any discussion? All those in favor say aye.
Aye.
Any opposed?
For the reasons I've already stated, opposing Sunday sales, I will vote nay.
All right. And of course, at this position, I do want to let everyone know that the judge is not required to vote on this, but I do hold that I approve of this ordinance, and I want that to be known. So at this time, I say we have an ordinance. Is there anything else I need to do? Okay, then we have a few things that we want to address on this. Wendy, do you want to give the timetable right now?
Yes, Jason and Judge and I spent a few hours together yesterday. Applications are nearly complete, as Jason said. I will hope to be able to get those out, I would say probably Monday, by the time we get our copies made and those sort of things. I have also discovered this week that I can build websites, so we will launch marshallabc.com this week. All of the forms will be on there. That'll be your easiest way to access the state forms, the county forms. Hope to have the city applications on there as well, all of our ordinances. And so marshallabc.com will probably go live Monday or Tuesday. I've got to talk to the county treasurer about some fees and how to do some of those things. But we will probably in court on Tuesday be able to have that live and kind of display it all. I've got a draft of it now that I would like for the court members to look at after we dismiss, just to see if there's any changes that want to be made, and then we can go from there. But don't advertise. I've been working with the Tribune Courier, since it's the paper of record, trying to make sure that the advertisements are done correctly. There were some miscommunications about the way the advertisements are done, but you have to submit the application to us before you advertise. So I just want everyone to realize this is a learning curve for the court, for myself, for the attorneys. So we are learning as we go, but I feel like we will get it done right. And so just kind of hang in with us as we proceed with the process.
Thank you, Wendy.
One other thing on forms, Benton and Hardin we're gonna copycat basically what Wendy does with these forms. So we're gonna have forms that are identical except for the letterhead for Benton and Hardin. I don't know about Calvert, if they're gonna use different forms or.
I understand, they're the same.
One other thing, it was our understanding in the beginning that the state would do the background checks, but we've been told otherwise. So when you do come with your application, there will be can we do that?
Well, I read over that. I meant to tell you that. We already take a $50 application.
Okay, so the background check we will have to do that on the county level. The state did do it, now they don't, so the county will have to do the background checks and get those sort of things done as part of our license regulations now too.
All right, I do want to say a few things. I do realize that this has been a emotional issue for a lot of us. I want to assure everyone that up until the time I'm through, which will be somewhere in November, but I am sure that the next ABC administrator is going to do the same. We're going to make sure that everything goes as properly as it should. We're going to make this something that is good for our county, not embarrassing for our county. I ask everyone that's going to be applying and wanting a license, bear with us, have patience with us. We're not going to rush anything. We don't want to do things incorrectly. We want to do them right the first time. We may make mistakes, but they will strictly be accidental, and we will fix them. Anyway, we appreciate everyone and all their input they've given us through this past month and a half, nearly. I hope you will let us know if you have any more information you think's relevant to what's going on. We'll be glad to listen. And at this point, unless, gentlemen, you have anything else to say, yes, sir.
I do have one question on the background checks. Who's going to be doing those?
That will probably do the office of the administrator.
Okay. We're going to have to do some things because I own the license to the NCIC computer store where you'll have to do the background checks. You won't have access to it.
Well, there's a link that the state provided us to use to do those. So I think it's a little bit of a different program than probably what you guys, the sheriff's department, use. But Jason and you and I can work together on that, and if it's a more efficient way.
I would rather it be a very thorough, good background check, and a lot of those sites I don't trust because I know ours works correctly.
Well, I mean, we can talk about that
Definitely.
and turning that part over to you. I think at some
Well, I
point,
don't have the
even
manpower to do it for right, I don't have the manpower to do that right now. That's why I'm wanting to know how that's gonna work.
But I'll maybe we can get a plan together and we'll discuss it in court on Tuesday, if that works with everyone.
I won't be here on Wednesday. I'm in service next week, but we
We'll
definitely
get a
need to
plan before.
discuss that.
Okay.
well, again, and that's why I'm cautioning everyone to have patience with us. You've waited 70-something years, so I think you have a little patience with us to make sure we do everything the way we should. Give us give us all you can, patience-wise. So, yeah, Sheriff, I think we can probably all get together and work on that and make sure we have the best way to do this. At this time, I would entertain a motion to adjourn.
That motion, Judge.
Is there a second? All those in favor say aye.
Aye.
Any opposed? Motion carries.